and Gareth, we're here today to talk about special trusts and the valuable role that they can play in one's estate plan. So Gareth, let's begin with you. So in terms of the Income Tax Act, it makes provision for the formation of a Type A and Type B special trust. Can you unpack the difference for us?
Yeah, sure, Sue. So I think the main difference between the two, like you rightly said, they're both registered under the Income Tax Act, which falls under Section 6B1. And the key difference would be that the Type A trust is set up for somebody who has a special need in the form of either a mental or physical disability. On the other hand, the special trust for Type B, those beneficiaries would need to be under the age of 18 or a minor in that instance to have that put in place.
So if we look at a Type A trust specifically, a trust that is set up for the benefit of those with special needs, that type of trust can be set up either as a testamentary trust or as a living trust. What are the circumstances in which you would set up a testamentary trust versus a living trust, for instance?
As the name suggests, a testamentary trust, I think first let's start there, is a trust that only gets registered and set up and comes into existence on the death of the testator, and the will becomes the trust deed of that trust. A living trust, on the other hand, is a trust that you can set up while you're alive, and you can start providing and transfer assets to that trust during your lifetime. So the benefits of using a living trust would be in the instance where you, as an example of a parent of a special needs child, are geographically far away from that child, or you travel abroad for long periods at a time, and that might not put you in a position where you're able to look after the needs of that child on a regular basis. In such a situation, you would like to set up a living trust for that child, and you can then appoint trustees that will manage the trust for the benefit of the child. It's important to understand that you, as the founder of that living trust, can be one of the trustees, but then you also want at least 2 additional trustees, one of whom needs to be an independent trustee who can then manage those assets on behalf of this special needs child. If you are confident that you can manage the assets for the special needs child while you're alive, a testamentary trust would be the route to go for you.
So Gareth, from a tax point of view, special trusts enjoy a special tax dispensation. Can you just unpack that for us?
So I think the key one there around a Type A trust would be specifically the capital gains element. So those, unlike a sort of inter vivos trust, would benefit from the usual 40,000 Rand annual exclusion on capital gains that individuals receive, and then as well as if there are any things that are deemed to be primary residence within that special trust, would also qualify for the 2 million Rand primary residence exclusion if they're ever disposed of.
So let's talk about the types of trusts. Obviously, there's different types of trusts that are involved in when one sets up a trust. What would the benefit be of setting up a discretionary trust versus setting up a vested trust in the case of a special needs child? A
discretionary trust, as the name suggests, is a trust where the trustees have a discretion to allocate benefits, either the income or the capital of that trust, to the beneficiary, who's the special needs child, where a vested trust is a trust where the trust deed allocates certain vested rights to the special needs child in terms of what income and capital they must receive on a regular basis, and therefore that takes away some of the discretion and the management of those assets from the trustees. So taking into account that the purpose of the trust is to provide for a special needs child, and therefore they would not be in a position where they can manage their financial affairs on an ongoing basis, a discretionary trust, typically it would be advisable to set up for the benefit of a special needs child.
And again, in that situation, obviously the trustees that you nominate, it's important to get that nomination right.
Exactly. So those trustees, as the name suggests, in a discretionary trust, they need to allocate funds on a regular basis. So it's important that those trustees understand the needs of that child and can allocate the funds accordingly.
It's important to understand that you can't just set up a special trust, Gareth. There's certain requirements that need to be met in order for that trust to be recognised as a special trust. Can you just take us through those requirements?
Under the Type A trust, there's a certain number of elements that need to be met, and there's probably three main ones. One, the special needs person genuinely needs to be special needs, so that's if they've got serious sort of mental incapacities or physical disablements. Usually we looked at the Mental Care Act for guidance on that, and that needs to have been diagnosed by a relevant qualified medical practitioner. In the same breath, those disabilities need to be of a permanent nature as well, not something that somebody could be seen to recover from. And then most importantly, that trust needs to be for the sole benefit of that special needs beneficiary.
Right. Let's talk about a minor child. Let's talk about the Type B trust, which is really formed for the protection and housing of assets of minor children, Eric.
The special or the Type B trust is set up for minor inheritance. The reason why the trust comes into existence is that in terms of our law, due to the person being a minor, they've got limited contractual liabilities and therefore the ability to inherit is not the same as a normal individual. For that reason, if a trust is not set up and the minor would inherit directly, that inheritance would either go into the guardian's fund or it would be placed under the administration of the surviving guardian if there are any. So to avoid that position, typically what you would do is set up a testamentary trust for that minor child, and that trust can then receive the inheritance and manage the inheritance on behalf of the minor child until they are of a major age or at a later stage as you might determine in your will.
And again, Gareth, there are a set of qualifying criteria that need to be met in terms of setting up a testamentary trust. Can you take us through those criteria?
So for a Type B trust, the beneficiaries would need to be under the age of 18 at the time of the estate being triggered and wound up, and within that year of tax assessment. When that is put in place, the trustees would obviously need to register the trust with SARS. Reason being, your Type Bs also get a tax benefit compared to a discretionary trust, where they are taxed on the PAYE tax tables, so sort of between 18 and 45%, rather than the flat rate that your discretionary trust would be taxed at.
So, I mean, the bottom line is what we're saying, the special trusts have got a valuable role to play in one's estate plan, but there are a set of qualifying criteria that need to be met in each circumstance. And it's important to understand the tax implications and obviously to get advice from an independent financial advisor on when it's appropriate to set up a trust.